Really thrilled about the topic, our panelists today, and really just the future in Virginia. It's been a bit of a long slog, but we're finally kind of turning the corner and really excited to kind of walk you through the licensing opportunities, the market, sort of economic side, as well as some corporate kind of financing things to be thinking about if you're looking at entering this state. So it's really an exciting one for the year. We'll give it about one more minute. We already have well over 100 participants. We're really humbled by that. And we'll get cranking here shortly. I think we're going to ask folks to put their questions sort of in the chats on the side. The panelists will be able to look at those if they're able to in real time, answer people's questions. They will. If we need to follow up after the webinar is done, we certainly will. So happy to have it be participatory as possible, given the fact that we got 30 some slides to get through. So with that said, I think we'll probably get going. Brian Vicente here. I'm the founder of the Vicente Law Firm. There's about 70 of us coast to coast. We do tons of cannabis work, a fair amount of psychedelics work. Been doing this for a couple decades. I'm really excited about cannabis policy in 2026, honestly, and I've been doing this for a while. But with the excitement going on at the federal level, with rescheduling, with hemp, is something happening, is something not? I think the most exciting state going on this year and the real kind of big dance will be in Virginia. And so I'm really thrilled to be kind of starting the year talking about this. It's a populous state, 9 million people. It's fairly, there's some serious urban concentrations. It's also largely surrounded by prohibition states, not entirely, right? You have medical in West Virginia, you have the whole enchilada in Maryland, but a lot of prohibition states, which generally lead to just being a strong market. And the timeline here has been bananas. Our law firm got involved, I think it was like around 2015, they started talking about medical. And then 2018, and my colleague JM will speak shortly, more specifics here, passed sort of a limited law. We did some licensing work, our law firm did, and I think 2019, 2020, we actually won one of the first big licenses in the state. So we've had a pretty good history there. And then in 21, they legalized, and we all thought, well, great, this is going to move forward really quickly now. But as we know, it was basically 5 years of nothing. And now the new governor, which we're thrilled about, has really made this a priority. We'll be talking about, essentially, she's making up for lost time here and these years that we've kind of forgotten. And we're looking at potential adult use sales, later this year or January. Those are kind of the proposals on the table. So super, super exciting. I'm going to turn things over in a second to my colleagues. We're going to be, discussing both the corporate side, the licensing side, the regulatory side, the bills that are out there in front of us, the econ. But first, I'm most excited to turn over to my friend JM Pedini. JM's been an absolute rock star in Virginia, not only as the head of Virginia Normal, but also as the development director of National Normal, and we've had a lot of interactions with that wonderful organization. And JM is going to kind of walk us through a little bit of the build up, the history, and then they will be jumping in on the state of the state as well. So with that, I'll turn things over to my good friend JM.
Yeah, hey, thanks so much, Brian. It has definitely been a wild ride here in Virginia, and we're ready to be at least one of the states that actually can get something done in 2026 and bring you that cannabis policy excitement that you're looking for. As Brian mentioned, I am a director at the National Organization for the Reform of Marijuana Laws. I happen to live here in Richmond, Virginia, and have the pleasure of serving as the executive director of the state chapter. And we have led the effort to first legalize medical cannabis, to decriminalize personal possession, and then ultimately to legalize and regulate adult use. And that's where we are today. I'm ready to go ahead and take a look at that next slide, and we'll sort of talk through how we started. So Brian mentioned this process really started in 2015, and despite Virginia having passed one of the nation's very first medical marijuana laws back in the 70s, nothing really happened between the 70s and 2015 when we finally passed an affirmative defense for possession of what we called at that time CBD or THCA oil. And it was only for intractable epilepsy. Now, what's unique about Virginia is not only were we able to move forward with this limited affirmative defense approach, but we were very quickly able to stand up a regulatory structure to serve this, what would have been a handful of patients, and then remove qualifying conditions altogether. We didn't hang more ornaments on that Christmas tree. We just said, you know what, let's let doctors decide. Instead, it was a very effective campaign, and I think we are the only state that took that initial limited licensure model with a singular condition and just moved very quickly into a no conditions, full access medical cannabis program. Ultimately, in 2020, we both decriminalized personal possession and outright legalized the medical cannabis program, which was really stood up under just an affirmative defense. In 2021, we were able to then go ahead and pass the first component of the adult use legalization bill. Now, as we all know, elections have consequences, and that's what we are dealing with still in Virginia nearly 5 years after passing this measure. At that time, we were in the midst of the pandemic. The legislature was having their very first virtual session, and they were able to come up with some ideas that were not a good strategy. And had experts been in the room with them, would have said, no, this isn't the right approach. But ultimately, they added this enactment clause to the adult use sales bill, component of that bill, and that needed to be voted on again in the following year. Of course, by that point, the Democrats had lost control of the General Assembly and of the administration, and they were not able to advance that reenactment at all in the following two sessions. In the next session, they were where are we now? 26. So in 24 and 25, we were able to get that bill to the governor's desk, who vehemently opposed legalization and just veto them outright. Now, during this process, we moved from a Board of Pharmacy regulator for the medical program, established an agency in the state specific to cannabis regulation, the Virginia Cannabis Control Authority, by promulgating the Virginia Cannabis Control Act, and moved medical under there as well. That's where adult use will live. And we have licensees in the state that are operational. I think we can go ahead and maybe move on to the next slide and talk a little bit more about that. We have the state is broken up into health service areas. This is dictated by the Department of Health and is not specific to the medical cannabis program, but it allows for one medical operator in each health service area, and they can ultimately have up to six retail facilities in their health service area. They wholesale between each other, so it's not just one product from one company in one area that you're getting. Now, as Brian mentioned, Virginia is the first state in the South to have legalized adult use cannabis, and we're a big state. Of that nearly 9 million residents that we have, 6.5 million are 21 plus, and we've got about 1.1 million adult use cannabis consumers here in the state. Now, this is looking at, let's say, upwards of $1.9 billion of annual consumption, 796,000 pounds at $200 an ounce, roughly. And that's a good price in Virginia.
Damn, Jim.
Sorry?
I just want to wondering if you want me to jump in now or happy to explain some of these slides.
Oh, yes. Go ahead.
Thank you, Jam. So Andrew Livingston here. I'm the Director of Economics and Research for the law firm. So these are just some high-level estimates of what kind of the Virginia market could look like. We'll be doing a in-depth market analysis and pro forma model for any clients who are interested, as potentially needed for the application. As will be discussed a little bit further, the application requirements, some of the details really aren't there yet. A lot of that is likely going to be kicked to regulation. So this kind of just gives a look, as JM was mentioning. Virginia not only is going to be the primary state to pass adult use cannabis this year, but it's also one of the large states. There's a few states left that still don't have large regulated adult use markets or even large medical markets, and that's Virginia, North Carolina, Georgia, Texas. So Virginia's, one of those significant ones with over 6.5 million residents and over 1 million residential adult use cannabis consumers. As far as what the market could look like, this, estimate of 796,000 pounds, really just looking at the number of resident consumers as well as their intra past month use frequency data. So that's essentially, there's data from the National Survey on Drug Use and Health that looks at cannabis consumption rates and then also looks at how many very frequent consumers there are versus less frequent consumers. And then if we were to, apply, a retail price point of $200 an ounce, what that would look like. But we're likely looking at somewhere between a $1.5 to $2 billion market in Virginia. That, of course, is just for residents. When we factor in border consumers, tourists, and others, we add a significantly larger population. As Brian was mentioning, Virginia is one of the states, because we're starting to edge now into the South, where there are a lot of border states without adult use markets. So Kentucky, North Carolina, Tennessee, and West Virginia have a combined cannabis consuming population that's 21 up of 2.8 million. And there's about 44.7 million overnight visitors to Virginia in 2024. So that's a little bit more than Maryland. Somewhat similar to the overnight visitors in Ohio, for instance. So, Virginia, we're going to be dealing with a quite large market. The question always is how quickly that develops and how it rolls out. Wonderful. Next slide.
Thanks, Andrew. I'm Meg Nash. I'm a partner in our Boston office. And now that we've kind of oriented ourselves to what has happened in Virginia and what is happening now with the market and those statistics, we're going to start to look at kind of the legislation and licensing opportunities that are on the horizon. So far this year, to Brian's point, now we're moving very quickly. We've seen two pieces of legislation, House Bill 642 and Senate Bill 542. Both were introduced January 13th, 14th, and have already gone through some amendments. For the most part, they're fairly consistent with respect to the framework for retail cannabis market in Virginia. It will be underneath the Virginia Cannabis Control Authority, which I think is ultimately a good thing. I think that, since the CCA took over, I think it was just in 2024 of the medical program, they've been eager to kind of get to the adult use side. So they will start accepting applications in July of 2026 with regulations that should be out by September of 2026. Sometimes it can seem a bit non-intuitive, I'd say, to kind of have this application process before you actually have regulations. But this is actually fairly common. We've seen this in other states, in New Jersey. I'm trying to think of some others, but a lot of that sort of will be reconciled with respect to the application itself and the forthcoming regulations, as well as the fact that there's already a successful, medical program that's up and running, which should inform, one would think, the regulations that we'll see from the CCA. The sort of primary difference between the House bill and the Senate bill is the timeline with respect to retail sales, although there's sort of a 90-day difference here. The House bill is looking at retail sales to begin by November 2026, with the Senate bill looking for retail sales to begin by January 2027. So again, a very steady clip here with respect to getting things underway, with this legislation issued in January and expecting sales, either January 27 or within the year. The way the legislation is currently drafted, there will be a cap at 350 retail marijuana stores that will join sort of the roughly 30 other medical dispensaries that are out there already through January of 2028. And there will be only 5 Tier 5 cultivation facilities until January of 2028. The Tier 5 designation in both bills, I believe, is 35,000 square foot of canopy. So fairly robust there. And I think it demonstrates a good emphasis on ensuring that the supply chain is there as kind of the retail side is getting up and running. Go to the next slide, please. Okay, so similar to what we've seen and what people might expect from other markets, there will be multiple different license types here. Cultivation, processing, retail marijuana store, a micro business, which will allow for vertical activities, cultivation, processing, and retail. A transporter, which is a B2B operations, transporting between licensees. Delivery operators, which will be permitted to deliver directly to consumers, testing facilities, as well as dual use marijuana facilities that will have, medical and adult use products. Next slide, please. So in addition to some of the language we've gone over already, we wanted to pull out these specific highlights because it will really impact, kind of the market considerations and kind of business operations going forward as you're, working with Andrew or with CPAs or other economists to kind of map out what this is going to look like in the future. There will be additional restrictions to mitigate undue market concentration. The legislation does kind of direct the CCA to ensure that there will be licenses throughout the state, that there isn't kind of this concentration in one specific area, and that localities will have sort of the time, place, and manner opportunities that we've seen in other states. The vertical integration is permitted. As we mentioned, this is how the pharmaceutical processors are operating and micro businesses. And there is a high conversion fee for dual use marijuana. Both bills include a $10 million conversion fee and a $500,000 conversion fee for hemp processors or growers. So not a small amount, but also not the highest that's ever been in the country. Both bills also have an 8% retail sales tax that can be kind of built upon by localities. But one important thing to note is that, as I mentioned at the beginning, both of these bills have already undergone changes after they were introduced in the 13th and the 14th. So there may be more revisions to come, but our office, our team is tracking it very closely and can certainly be a resource as this makes its way through the legislature. Another key consideration is the prioritization of impact licensees. The term impact licensees is used throughout the legislation. This is somewhat comparable to what we've seen in some other states referred to as social equity licensees or disproportionately impacted licensees, just as sort of a point of orientation. Impact licensees will receive preferences in the licensing process. That comes through the waiver of fees, as well as access to low interest business loans, and a waiver to require proof of funds. There's also, kind of this requirement about ensuring that licenses awarded to kind of a proportional distribution to impact licensees, kind of where that is going to land, whether it's 50% of licensees will be impact licensees or otherwise sort of remains to be seen. But it's clear from the way that the current language is drafted in the proposed legislation that this will be a policy priority moving forward. And just to kind of pull that out a little bit more, there are specific qualifying factors that we've seen in the legislation so far in order to qualify as an impact licensee. We anticipate that some form of qualification procedure may very well kind of kick off that licensing procedure, similar to what we've seen in Rhode Island, Maryland, Minnesota, so that people can sort of plan accordingly going ahead. So the sort of particular designations that you would need to qualify as an impact licensee, we have these factors listed out here. One is if you've been convicted or adjudicated delinquent for a misdemeanor or felony under specific criminal codes. if you're the parent, child, sibling, or spouse of a person who's been convicted for a felony under certain criminal codes, kind of tenure at a specific residence, or attendance at a public elementary school, whether you received a federal Pell Grant, or if you're a veteran of the armed forces, or if you qualified for financial assistance or relief from the U.S. Department of Agriculture. In the initial draft of this legislation, the requirement was to meet 4 out of the 7 kind of criteria. That has since been amended to include 1 out of the 7 criteria. So it should kind of cast a broader net with respect to ensuring that, more individuals will be able to qualify. And before we kind of dive into the application and licensing process, I wanted to just turn it over to JM quickly as our boots on the ground Richmond expert for their thoughts on kind of what we might see in this legislative session.
So the Senate bill is up tomorrow in Courts of Justice Committee, where it'll largely look at the criminal content of the bill, the penalties, and there's what we think to be a sort of holding pattern on moving the bills into finance until the Senate bills get into finance. There's a third bill that was filed in the Senate, so there's 2 in the Senate and 1 in the House, and this third bill is at best a political football. It doesn't appear to be a really serious take at legalizing retail sales, but there are a lot of political implications that come with that and will definitely impact the trajectory of this legislation.
Thank you. That's definitely helpful. And, we're all kind of taking a hurry up and wait and see what happens approach as this is happening. But to the extent that, changes are made, we will be blogging, we'll be webinaring, and we will be reaching out. But certainly if you have questions as well, we're available. So now getting into, kind of the fun part, but with some tea leaf reading at the same time of the application process. There's still kind of some questions out there. The legislation we have so far does not say whether or not this will be a competitive licensing process. For reference, all the prior medical applications have been merit-based competitive applications. So, they may stick with what they know in that regard, with the caveat that the last medical application was scored merit plus a lottery. So we may see that as well. And it may be sort of that hybrid approach of a qualified lottery where you have to kind of pass to get into it, or, if it's just a lottery, and we'll see. And then there's kind of the appeal options with respect to what that's going to look like. We're really going to expect that more in the regulations with respect to how that is going to work. And a lot of, in a lot of emerging states, what we've seen on the appeal side also begins with the impact licensee qualification as to whether or not, there's sort of a process there, and if that's something that needs to be addressed. So some things that remain to be seen, but worth kind of considering at the outset as you're strategizing and thinking about, drafting these applications, writing for your audience, and putting those pieces together. So Charlie will take us through sort of later in the hour a lot of the application readiness, which frequently has a lot to do kind of on the corporate structure and thinking about how, each entity will be raising capital, pursuing real estate, particular intellectual property. So I will let kind of our resident expert speak to that without going into it too much, but worth flagging at the outside for sort of a very key component of application readiness. And a lot of that also includes making sure you have the right team around you, including legal service, legal professionals, CPA. The cannabis industry is still subject to unique tax provisions. So, and then other subject matter experts, particularly with respect to kind of the cultivation or processing licensees. It's important to think about sort of who is going to be on your team, whether that's you or whether you're recruiting sort of outside experts to assist in that. General tips for a strong application. It's important to ensure, that your kind of due diligence is completed, collecting any anticipated required documents for the application itself. Again, that may very well start with respect to having to demonstrate that you qualify as an impact licensee. It's typically not sufficient to say, oh, I qualify, under this category. A lot of times, whether it's a document for the Department of Defense to demonstrate that you're a veteran, or court records to demonstrate qualification under another one of those criteria. All of those can be a bit of a headache to gather. So particularly kind of on the impact licensee side, if that's something that you're interested in pursuing, it's helpful to think about what those documents might be. And then in addition, thinking about sort of your structure and kind of the build out costs, all of that. And certainly Andrew has been immensely helpful to all of our clients, not only through past Virginia licensing rounds, but in all markets, and kind of providing data-driven analytics and predictive analytics. So good to keep in mind as you're kind of planning ahead here. What we know so far from the regulation, from the legislation, is that there will be kind of specific components that you're going to need to think of. A lot of the information kind of set here appears to be what will be required after sort of receipt of your license, or a conditional license as it may be referred to, because there is not a property requirement at the outset, at least under the current legislation. But eventually there will need to be sort of a local notification at the proposed place of business, have to go through the local approval process, submit a labor peace agreement. So even though you're not necessarily going to have to provide a lease or a contingent lease agreement at the time of the application, obviously property will be a requirement, to get up and running and operational. So it's always something to think about, even when it's not required, and even in consideration of sort of those market factors, population density, access to employees, those type of things. There is not an explicit capitalization requirement. So for example, the legislation doesn't say retail licensee applicants have to have $500,000 of liquid capital available. Generally, that's a good thing, again, because it's sort of, you don't necessarily, particularly if this is going to go through sort of a lottery process, so that you're not necessarily doing all the legwork to bring in investors for a specific amount just to apply. But at the same time, the application does require there's sort of right to refusal, I guess, rests with the CCA if you've not demonstrated financial responsibility sufficient to meet the requirements of the business proposed to be licensed. And that language with respect to the business proposed to be licensed is really looking at, what is the specific startup capital required for a retail license? That's likely going to be less than a tier 3 cultivation license, given the kind of equipment and security and property. Obviously, there are variables there, but it's going to be important to understand, not only from a business perspective and from a planning perspective, what the prospective costs will be, but also for an application perspective to demonstrate kind of thoughtful approach to this, and that you've looked at properties, you've looked at the market, you've reviewed equipment, that you have the financial responsibility sufficient, and that the amount that you're showing on the application is tied to specific, fact-based information and data that's going to help in kind of satisfying that requirement. Different states have approached this differently and at different stages. So, for example, in neighboring Maryland, there wasn't a initial capitalization requirement on the application, which was selected via lottery. But then for the supplemental application, there was a specific number required, and that number changed based on the type of license that you had. So again, while this isn't expressly called for in the proposed legislation, it's never too early to start thinking about these things in terms of, both the licensing application to demonstrate financial capability, but also to ensure kind of long-term success as, each entrepreneur travels this path. And with that, I will pass it over to Charlie to take us further into kind of these capital considerations and kind of speak to the importance of that more than I have.
Okay, yeah, thanks, Meg. All right, so I'm going to start with just talking about sort of general considerations when doing transactions involving licensed cannabis businesses. And then we'll talk about the Virginia specific stuff. And the reason I'm going to do it that way is because we don't really know what the rules are going to be in Virginia yet. First off, we got really two bills, but three bills total, right? Not that they differ very much, the two main bills, but we don't have the regulations yet. And sometimes the devil's in the details with the regulations. So, I can't give you a definitive answer, right, for a lot of this stuff because, again, don't have a final bill yet, don't have regulations, but I can tell you what to look out for, right? And then, of course, we'll have the answer as soon as we get there. All right. So the first thing to look out for is whether you can change ownership during a preliminary license phase. There's nothing yet in the bills except with respect to impact licenses with respect to this, but it's pretty common not to the ability to flip a preliminary license. You have to get to final before you can change control. And then in some states like New York, years after the state has launched the system, they still have no procedure to transfer control of a license. So that's another thing to bear in mind here is that, Virginia's moving quickly here, but they have to create procedures for changes of control, and you got to wait for that to come out before you can actually effectuate one of these things. Next slide. All right, so let's talk broader M&A, right? These are things that regulations will often cover that you got to think about. Is written pre-approval required prior to closing? So, very common require written pre-approval to change control. Not always the case for changes of ownership below control. Sometimes you just have to disclose this, but obviously it makes a huge difference for a deal if you need to get approval to change a certain percentage. We'll talk about Virginia, what Virginia specific in here. Are there local license approvals required in addition to state approval? Here, that's a no. In Virginia, there's not going to be a local license. There is zoning issues, though, as well. And of course, any kind of M&A transaction in cannabis, the landlord is a pretty critical component, right? One, first off, because with a lease, oftentimes change of control require consent from the landlord. They often require an additional guarantee, but also because, the buyer is going to have to be okay with whatever the terms of the lease are. And, it's a big thing, especially in other states where we're dealing with a lot of distressed M&A, is sometimes these leases are toxic and it kills the deal because no one wants, whatever the square footage price is the landlord's been charging for a few years. Are workarounds regulated? So states have gotten wise to this, but a lot of times, like in other states, you don't sell the license, but you do like an MSA transaction or you do an IP transaction, or there's some sort of option arrangement. These are being regulated much more heavily than they used to be. How difficult it is to move a license, i.e. a change of control. And then, of course, the big one is like, what's actually happening in terms of practice is a big question because, like, again, looking at New York as an example, New York is a state where the regulators tell you, well, there is no mechanism to change control of a license. But then, you talk to some broker and they're like, oh, I've closed 50 deals. Um, and what's happening here is, the regulators will create a regulated system and then they will not enforce aspects of the regulated system, and the market will sort of do what markets do, which is, buying and selling and prices getting pushed down. That will happen if there is not active enforcement of the rules. That's M&A. All right, so equity considerations. This is, stock selling equity in a company. Um, Material level for approval creation in various states, whether, to add a small shareholder, you need to get pre-approval, or whether there's a materiality threshold. Virginia, by the way, that's 10% right now. Um, so obviously it's a lot easier to do an equity raise if you don't need to get approval because that's something that slows you down from bringing in money. Another big question here is veto rights and control, meaning like, sometimes in a typical financing deal, the investors will want protective provisions to protect themselves. And the question is whether that rises to a level of control. That can be an additional issue in social equity deals or impact licensing deals. Board members, you want to add someone to your board? Does that require approval? Important question. Are your investors comfortable with a background check, and what does that check look like? And is this publicly listed in any way? This is the one where I would say, like, this is a key question to ask at the onset. What you don't want to have happen is, you've raised money, the investors own equity in your company, the regulators ask for something, and your investors say, yeah, I'm not going to give you that. So I've seen this happen a lot, and you get caught, right, between an investor who's like, yeah, I'm not going to give you that, that's illogical, and a regulator's like, I want this, I don't care what the investor says. And now you've got an investor who won't do what you want and a regulator who don't you want, and you're trapped in the center. So the way you get away with that, avoid it, is you got to confirm upfront what it's going to look like and make sure your investors are okay with it. And then rolling closes, that ties into materiality, right? If you need every shareholder to get blessed by the regulator, you can't really do a rolling close because that's going to involve like multiple submissions. If there's a materiality threshold, then you can do a typical roll and close for a raise where it's like, as people invest, you take in the money, you sign the docs. And so there's, like maybe 20, 30 different closings, what have you. Next page. Debt. So debt is obviously this is a hot topic in cannabis because so much of the money going into larger cannabis companies is in the form of debt these days. And you're seeing note holders take over control of cannabis companies as these companies default on their debt. And, the debt holders take the keys, right? So the debt holders become the new equity holders. Debt is really is all over the map in terms of how it's regulated. Some states will require pre-approval. That's very unusual. Usually you don't require pre-approval. Sometimes they just require disclosure. And then in terms of like what the background check of lenders looks like, are there restrictions on loan collateral, restrictions on covenants, and then what happens in insolvency? This can be kind of all over the map. A lot of states will now have procedures for cannabis receivership. Though receivership is no longer the trend. The trend is now like Article 9 sales is what you're seeing, which we can kind of be on the scope here. But yeah, debt's kind of all over the map, but you gotta think about this before you take on debt. Next slide. Yeah, so I mean, just in terms of raising money generally, I guess just taking a step back here in terms of like lining up money for an application. So we don't know exactly what it's going to look like, right? But a lot of times, people will show capitalization to win a license. And then once they win the license, they'll go back and they'll raise more money or they'll raise separate capital. Obviously, it's a lot easier to raise money if you've actually won a license, right? Because now some people's inviting to something real as opposed to like, hey, do you want to sponsor my attempt to win a license? That tends to have to be self-financed. But so this is just raising capital, generate some pointers, right? Anticipate the investor regulatory questions, use a typical financing structure, be aware securities law still applies, be wary of investors that have never done a cannabis deal because you don't want to be caught by one of these surprises, or at least have that conversation up front. And then, yeah, my big one is just be careful of scams. There's definitely scammers out there, and if you win a license, you're going to get hit up by a bunch of people, and some of them will be scammers. So the big tip off here in my mind is either someone wants to do something really, really fast and without legal counsel, or they're, hey, send me $15,000 so we can run this credit check and then we'll loan you the money. You got to be careful about giving someone money up front because oftentimes you'll never hear from them again. All right. So, okay, let's talk about this. This is the real meat of the presentation here. Um, what do we know about Virginia? Okay, so and these are the two committee bills, the two real bills I'm talking about here. The third bill I haven't really spent much time on, so we're not gonna get into it here. But they pretty much overlap with all this corporate stuff. So we can sort of say this is what the bill currently says. We don't know what the final bill will say, and we don't know what the rules are say. But let's just assume that these bills pass as is. Ownership interest is 10% or greater of equity, which means voting or economic interest. So this is good because, some of the original stuff went down to the individual, which makes it difficult to raise money. So I think this is a very positive change because this way you can bring in new shareholders below the 10% level, not have to get approval from the regulators, most likely, which is going to make it easier to raise money. It's also very difficult to get a down to the individual person cap table because your investors are not necessarily going to tell you who their investors are. Officers, directors, managers are included in the definition, but that's usually not an issue because if someone wants to run a company, background check should be assumed. But if you have an investor who wants to stay out of the background check, you could just say, listen, you got to stay below 10%. You can't be an officer of the company or a director or a manager, what have you, which is fine because most people who invest in companies don't want to run the company. They just want to sort of join in on the risk journey. Tracing through intermediate entities, expected. Disclosure required for ultimate beneficial owners, mean they'll go up the chain. I didn't see any kind of exemption for public companies, but there's basically that 10% threshold, which a lot of states will put in place for public companies, but they treat public and private companies the same for ownership purposes. All right. This is a big one, vertical integration license caps, right? So vertical integration is permitted, subject to the caps. 5 licenses per person, excluding transporters. Only 1 Tier 5 cultivation license per person. The micro businesses and the testing ones are fully siloed, meaning that you can't have that and another type of license. So, you could have, right, up to 5 dispensary licenses. And you'd be capped out in your temporal licenses. But again, it's an interesting cap because it's like all licenses get picked up by the cap. But vertical integration is permitted, subject to this undue influence stuff, which I think is in the next slide. And then if you're below 10%, it shouldn't impact the cap, though we got to see the final language here on the regulations to talk about that. All right, so changes of control, right? So prior written approval is required for license transfers. Now, they call it a license transfer. In the corporate world, this would be called an asset deal, which, by the way, is how most cannabis deals are done these days because people don't want to pick up liabilities they don't know about. So they just want to buy certain assets for a company. Some states do not permit asset deals, right? So Pennsylvania would be a big state where you can't do an asset deal, which blows up deals and means basically the company just gets shut down. So I've seen people shut down facilities as opposed to sell them because no one wants to buy the equity. But yes, that's ownership changes and changes of control. Now, here's a new concept in Virginia that I haven't seen in other states, which is if you see a cumulative transfer of 25% or greater within 24 months, that requires a change of control approval. I have not seen that in other states. Usually other states just, have this sort of materiality threshold. What I think they're trying to pick up is listen, I could sell my business basically to, in pieces without getting consent. They want to get consent here. That's an interesting concept to just sort of track. I haven't seen it in other states. Um, all right. And then, pretty strict approval rights with respect to financing agreements. I don't know what financing agreement means. Uh, I mean, I guess you have to see what happens in the rules, but my take would be like, yeah, I mean, a loan would probably be a financing agreement. So I think you need approval to take on debt in Virginia. I don't know for sure yet. That's a big one, but certainly management agreements and brand licensing agreements. So like these are ones we see all the time in new states, right? Is someone wants to sell their brand in Virginia, that licensing agreement needs to get approved by the CCA. So, of course, sometimes it's someone wants to get their brand in the state. Sometimes it's I want to do a M&A transaction without getting it approved, right? So you'll do it through like an MSA and a brand license. Anyway, needs to get approved. The other thing here that's a little bit unique in Virginia, it's not super unique because we see it in New York as well, is this undue influence factors, which they've taken from alcohol, right? So alcohol is very different than Virginia cannabis because alcohol is a three-tier model where the production, the distribution, and the retail sides are meant to be separate. And they don't want undue influence in alcohol because they don't want the producer to control the bar, the retailer, right? This is something that happened pre-prohibition and it creates a lot of social problems, right? But they've ported this over from alcohol into cannabis. So while a producer could own their own store, if you don't own the store, you can't have, quote, undue influence, which is like price setting, shelf space control, shared personnel. Because again, I think what they're really concerned about here is market concentration, is you could have a few major producers that basically, control all the stores. Yeah, and then this is another thing in Virginia that's unique is this market concentration language. So this HHA style concentration benchmarks, which is what's used in federal antitrust law, they're going to use to potentially deny or condition deals, even if the license caps are satisfied. So I don't know what the thresholds they're going to use are. I mean, to me, it seems like if you've got 350 retail stores and the most you could have is five, I don't think 5 out of 350 poses a concentration issue unless it's hyper local. So this is another one we'll have to see how it gets played out. But I haven't seen this before in cannabis regulation explicitly saying in a statute, oh, we got to look at the HHI before we can approve a transaction. Yeah, and then impact license. So this one, in my experience, it is very, very tough to raise money for a social equity license when the restrictions are very tight. Um, And I would say it's going to be very difficult for these licensees to raise capital because pretty much any standard commercial arrangement will violate these rules. Um, it's the control remaining with qualified individuals that's the tough part because the investors will want some sort of protective right to protect their investment. And I, I mean, we'll have to see what the rules say, but it's going to be based on this language. It sounds like it's probably going to be tough. You also can't sell these for 5 years. The other licenses, there's no restriction in the statute, at least on flipping them immediately, but you can't flip these impact licenses immediately. You got to wait for 5 years, which of course in cannabis is an eternity. Um, and it's got to be 66% owned by the impact licensee. That can sometimes be less of an issue than the control, but just be aware you've got heightened restrictions on these licenses, which is going to make raising capital especially dicey. And then I'm gonna turn over for my we got 10 minutes left to talk about federal policy changes, but just to sum up real quickly, some unique aspects of Virginia, corporate deals that we haven't seen in other states. Just be aware, you can't just port over, hey, we did this in the other state into Virginia just because there's some new concepts in Virginia. And then two, yeah, this'll, by the end of the year, I'll have definitive answers for this stuff now, but a lot of this stuff, I can't give you a definitive answer yet because we just don't have, we don't have a final bill, you don't have final rules yet. And then, of course, the big factor here, I guess the third point is market practice. And certainly if any regulators are watching or any legislators are watching, I would say that my plea to any cannabis regulator who will listen to me, and I've been doing this for over 10 years, is um, the market will follow the rule, not the rules that are written, but the market will follow the rules that are enforced. So if you set up a regulatory system, however perfect it may be, and then don't enforce it, you're just going to see wild disregard of the rules, and you're going to penalize people that are compliant because you're effectively raising their cost of capital vis-a-vis people that don't follow the rules. So that's my plea to regulators is please, whatever system you put in place, just enforce it as it's written, enforce it equally, enforce it across the board, and you're going to see, the market will react to that because people ask me, hey, what are the regulators doing? And if I can tell them, hey, do this, you're going to get your hand slapped, they're not going to do it. But if I say, hey, listen, the rules say X, but we have not seen enforcement, but I encourage you to follow the rule because that's my, I'm obligated to say it, then our clients are not always going to follow the rules. Just because they're going to make a business decision that is like, listen, a certain percentage of people or the majority of people are not going to make it. And the people that follow the rules, when no one else follows the rules, are probably not going to make it. So people adapt accordingly. And with that plea, hopefully not falling on deaf ears, I turn it back to my colleagues, Brian and Andrew. And sorry, last thing I should say is I am based locally to Virginia. I'm in Bethesda, Maryland. So very excited about the Virginia market.
Thanks, Charlie. And I think Andrew's going to cover a little bit of federal stuff, and then we've had some wonderful questions in the Q&A, and I think we're going to try to reserve a couple minutes of panelist time to address some of those. So, Andrew, can you walk us through some of the excitement at the federal level?
Absolutely. So a lot happened in Q4. Can you guys hear me okay? A
Yes.
lot happened in Q4 2025. The first major thing was in November, as part of an appropriations package, changes were made to the definition of hemp. That will, if nothing changes before the 1 year implementation timeline, that will put a lot of screws into the existing hemp program, which will impact, things like whether or not North Carolina consumers decide to come to Virginia for adult use cannabis or, continue to purchase intoxicating hemp products from elsewhere. And then in December, President Trump signed an executive order expediting the rescheduling process. So it doesn't mean that it's automatically rescheduled now, but he directed Attorney General Pam Bondi to expedite that process and kind of push it over the line. We're expecting kind of continued movement in both Q1 into Q2. So it's not going to happen immediately for rescheduling, but it very likely will happen this year. Just hearing some things this morning that things are on the move. In addition, that rescheduling announcement for the executive order included a small portion that then is being currently implemented that directs HHS and really directs CMS, which is the Center for Medicare and Medicaid Services, and CMMI, its Center for Medicare and Medicaid Innovation, its subagency, to put together a first of its kind pilot program that is looking to implement real world evidence for medical cannabis. And so we are going to be able to see patients access medical cannabis. It's likely going to be hemp derived CBD products through kind of this federal program. It's not going to be from the feds. It's not going to be paid directly by the federal government. It's going to be called what's called a beneficiary engagement incentive through CMMI. If you guys are interested in this, we can have a lot of information and we can provide some more, but it gets a little bit nuanced as it deals with federal healthcare bureaucracy. But that's kind of fascinating. Also, as part of that executive order, the White House directed, essentially their legislative policy staff to work with Congress to revise that definition of hemp-based products. That PL 11937, that is the appropriations bill that changed that definition. So we've got a 1 year timeline until that becomes effective in November of 2026. And what we're going to try to do is change some of that language because otherwise that medical program won't really quite work all that well. So that's happening, and then there's also some congressional bills being put forward in both the House and the Senate to delay that 1 year timeline from November 2025 to November 2026 for another 2 years. So that wouldn't become effective until November of 2028. try to create some more breathing room to establish a regulated program for consumable hemp products in the United States. And then
Thanks,
I will
Andrew.
toss it off to Brian.
Yeah, thanks, Andrew. And if anyone has any questions, our office is very involved in a lot of these federal changes and happy to chat offline. So I think the $1 million question I'm going to throw at JM and Meg, and we've had a couple people in the chat ask, Meg, you've been doing this in a lot of different states for a long time. JM, your fingers on the pulse. When do we think we'll see applications? What's your best guess?
I think ultimately that's going to be dictated by the date specified in the bill, whether we drill it down to CCA has to be ready to start issuing licenses by a certain date, or if it's just how can CCA math backward from that date of licensing. I think they're generally prepared to be able to issue at least some applications beginning July 1, and July 1 would be the date of efficacy for the legislation in the state, regardless. So I don't think they are excited about having to issue a lot of licenses July 1 potentially, but in conversations we've had with them, that they understand that there's a possibility that would need to be prepared to at least issue some.
Yeah, and just to kind of piggyback off of that, I do think that there will likely be a phased rollout here, that July date will be looking at kind of the dual use, getting the conversion fees. I think the legislation July 1 date is also initially tied to the micro business license type and then hemp growers. And again, there's some logic to this to ensure that there's not 100 retailers and 5 cultivators who can't kind of supply the retailers to kind of have the retail businesses succeed. So we may see sort of this initial hybrid licensing or conversion licensing or vertical licensing that is then followed by a more general application round for retail cultivation, processing, transporter, the rest of it. So that would be sort of my best guess, but I'm kind of very optimistic that we're definitely going to see something in July, whether that's going to be kind of limited to a subset of licensees initially with kind of a phased rollout, or more of a opening the gates. I think that to JM's point, the CCA doesn't want to be overwhelmed by applications that would kind of hinder their ability to act quickly. So, that's my prediction.
I really appreciate that. And honestly, July is not that far away. So, I mean, really, for folks that are interested in entering this market, the time to start checking the boxes that Meg's talked about, the getting your team together, property, money is really now, and we're happy to chat with that. Meg, I'm going to do two quick technical questions to you, and maybe we'll close with Andrew and Charlie. Transport. Number of questions in the chat about transport. Can companies do in-house transport? Are they mandated to have a third party? How do we think that'll look?
The way the legislation is drafted, cultivators and processors are allowed to transport to other marijuana establishments. I think retailers are allowed to transport to each other. I think the way that this plays out is that most kind of cultivation processing licensees are not going to be focused on adding that factor just due to additional expenses, including like a commercial auto insurance policy, purchasing vehicles, that they'll be focused on getting up and running on cultivation, all the equipment, the property needed for that. And we'll outsource this, but certainly as the market matures, there may be some benefit to taking that in-house.
Okay, wonderful. And just with the final minute, Charlie, Andrew, quick thoughts on what state do you feel like has the most similar regulations to Virginia in terms of what we've seen thus far? Thoughts there, and I guess that's a little bit of us crystal balling how things are going to go. So either of you gentlemen want to jump in on that?
I mean, I would say there's still so much we don't know because of things that get kicked to the regulatory structure. So whether or not there's a limited number of licenses or not, or whether or not there's a lottery or a merit-based application process is going to change dramatically what the nature of that market looks like in its, first 6 to 12 months of development. So without knowing that yet, it's a little bit up in the air. Charlie, you have any other thoughts?
I mean, I'm gonna say like of the states that I'm most involved with, like probably closest to Massachusetts in the sense that it's vertical integration is permitted. Their license caps. Now that Massachusetts didn't have limited licensing, so right, it doesn't really map on perfectly to any of these states. And like, yeah, of the East Coast states, like like it's not like New York because it's the vertical is permitted. But they again, they've kind of picked, it's like it's a potpourri of stuff that you don't see in other states. Like they undue influence really you only see in New York, right? So, but it's clearly not based on New York. It's very different from New York. So it's a chimera, I say, as opposed to like a copy of another state system.
Gotcha. Which of course will make things really fun. So buckle up your seatbelt. Every state does a little bit differently, and I think we did a great job laying it out. I really want to thank the panelists, JM, Meg, Andrew, Charlie, and we are around to answer any questions via email or hop on the phone. With that, I'll let y'all go. Thanks for tuning in.
Thank you.
Thanks all.